Workplace defamation is not limited to public social media posts or newspaper articles, and many people are surprised to learn that private group chats, workplace messaging platforms, and direct messages can still give rise to defamation claims. In Queensland, the key legal issue is publication, which simply means communicating a defamatory statement to at least one other person than the individual being discussed. This means that messages sent through WhatsApp, Messenger, Slack, Microsoft Teams, internal email chains, or workplace group chats can potentially satisfy the publication requirement, even if the audience is relatively small. The fact that the message was intended to be private does not automatically protect the sender from liability. Workplace defamation commonly arises where employees, managers, contractors, or former colleagues make allegations about dishonesty, misconduct, incompetence, harassment, criminal behaviour, or other conduct that may damage a person's professional reputation. Even where a person's name is not expressly used, liability can still arise if the recipients of the message can identify who it is being referred to from the surrounding circumstances. A common misconception is that statements made in a private group chat are somehow exempt from defamation law. In reality, courts focus on the content of the communication, how an ordinary recipient would understand it, and whether it was communicated to another person. The informal nature of workplace messaging platforms does not reduce the legal risks associated with making serious allegations about colleagues or employees. Importantly, forwarding or repeating allegations can create liability even where the sender was not the original author of the statement. A person who republishes defamatory material may face legal exposure in the same way that a person who first made the allegation. This is particularly relevant in workplace environments where rumours, screenshots, and forwarded messages can spread quickly between teams and departments. There are defences available under the Australian defamation law, including truth, honest opinion, contextual truth, and qualified privilege. However, these defences are highly fact-specific and do not apply simply because a person believed they were speaking privately or expressing a personal view. Whether a defence succeeds will depend on the content of the message, the circumstances in which it was published, and the evidence available. Because workplace defamation disputes often involve employment relationships, reputational damage, internal investigations, and digital evidence such as chat logs and screenshots, understanding whether a message crosses the line from workplace discussion into actionable defamation can be critical. Early advice can help assess whether the claim exists, what defences may be available, and what steps should be taken before the dispute escalates further. Contact us today for a free 30-minute consultation with one of our experienced team of commercial litigation professionals, and let us help you protect your rights.